So let's make a start. This first thing we're going to look at is this idea that an effective legal system is made up of different elements. We can break it down into smaller parts. And it's really important at this stage to recognize that I'm not talking about the elements of an effective law. And if you mix those things up, you'll be talking about the wrong topic. When we talk about an effective law, a law must be known, a law must reflect society's values and the like. But that is not what we're talking about here. So when you see effective legal system, we're not talking about an effective law. We're talking about how the system works and whether it works in a way that is fair. So then we have a look at the legal system. And just as a very basic definition, the legal system consists of the rules, institutions like courts and tribunals, like VCAT that we've looked at, processes and procedures that have been put in place to maintain peace and order in society. And this is one way of looking at the legal system, that there are three elements that make this legal system really effective. And you'll see an acronym about to appear, F for fair and unbiased hearing, A for access, and T for timely resolution. So I like to refer to this as FAT. Okay, so it's one way of remembering the three elements of an effective legal system. And we're going to go into this in a lot more detail. The big tip for you here is that the entire Unit 4, and you saw how much is in it, the entire Unit 4 revolves around the idea of a fair and unbiased hearing, access and timely resolution. Of course, we'll need to understand what these mean before we start breaking down other parts of the legal system from this perspective. So firstly, fair and unbiased. This kind of goes without saying, but in an effective legal system, people should be able to get a fair and unbiased hearing. And this stems very much from our idea that that is simply the right thing to do. Our morals would tell us that you can't just accuse someone or put someone in jail without working out why that person needs to go there. And you'll see this logo here, which hopefully you recognize is the logo of the United Nations, from which we have a set of universal human rights. And it's the hope that your legal system, our legal system, recognizes society's current values and human rights. There's also this idea of natural justice. There's some Latin here for you. You don't need to know it, but certainly if you go into an in-depth study of the law, Latin maxims or Latin rules become something that appears a lot of the time. This one's nemo debet esse judex in propria causa, and I'm not going to even try and claim that's the right way of pronouncing it in Latin, but what this means is that no man shall be a judge in his own cause. That's to say, if you have a financial or some other interest in a dispute, it might be really difficult to make a fair decision because you're kind of one-sided. So it's from this idea of natural justice that we get the concept of a judge being an impartial and unbiased party. There's always a person in the middle who doesn't take sides. Audi alteram partem is another principle of natural justice, and again it means to hear the other side. Okay, so you'll see the word Audi here, like audio, to hear the other side. Each party must be given the chance to present their side of a case. If not, this gives rise to a right of appeal. And that's something that we always see in our cases. There's always a plaintiff and a defendant, or there's the prosecution and the defense, and both sides present their case. If that doesn't exist, then we can say that the principles of natural justice haven't been met, and therefore we don't have a fair and unbiased hearing. There are also processes and procedures that provide for a fair and unbiased hearing. Lots of different details here. For example, the adversary trial, this idea that we have two sides fighting out a case in the hope that if both sides present a really strong case, or the best case that they can, then whatever results, whoever wins, that must mean that the party had a better case and that it's a fair outcome at the end. We also have this idea of legal representation, that not everyone is an expert in the law and that it makes sense to make sure we have people like lawyers to represent our interests in the court to make sure that procedures are followed. There are things like the right to silence, typically something I'm sure you're familiar with from watching American television. You have the right to remain silent, but this is also a procedural right that you have, that just because you don't say anything doesn't mean you're guilty. It's simply your right to not say anything that might incriminate you or get you into trouble. There are many, many rules of evidence, ones that I've probably mentioned before, and you're familiar with in a courtroom where a lawyer on one side or the other might say, objection, or more typically in an Australian courtroom, Your Honour, I object, something like that. And it might be things to do with hearsay, the admissibility of different types of evidence, how that evidence was collected, whether it was collected legally or not. And again, having those strict rules of evidence allow for a fair hearing to occur. There's also the standard and the burden of proof. And hopefully you can remember that in criminal law, we have a burden of proof that lies on the prosecution, and that the standard that they are held to is beyond a reasonable doubt. In a civil case, the plaintiff bears the burden of proof, and the standard is on the balance of probabilities. The jury. In a criminal case, we have 12 jury members picked out randomly from the public, and the jury is there to make sure that the wider community can be involved in ensuring that a fair hearing occurs in a courtroom.